One judgment is there from, actually, some problem was there in chamber. It's pronouncement of one judgment from justice.
Pronouncement of judgment. Criminal appeal say 9 of 2018.
Mr. A.M. Datta was there, I think, amicus. In view of the aforesaid
Yes.
facts and circumstances, we are of the considered opinion that the prosecution was able to prove the case against the appellant beyond all reasonable doubt and had come to a correct finding of guilt and thereby so and so. Appeal stands dismissed. We record our appreciation for the assistance rendered by the learned amicus.
Criminal appeal say 6 of 2021.
This is which case? People tree. People tree. Fighting with
People yes. Okay.
in view of the aforesaid discussion, we are of the view that that the materials on record, including the evidence, would not be sufficient to come to a conclusion of guilt of the appellant. We accordingly allow the appeal. We record our appreciation for the assistance rendered by Sri Datta.
Item 1.
1 to 3 years later.
Under conviction under
It was that first. So,
POXO. First is POXO. POXO hole aro heri jabo, huh? POXO number 37. Devanga Kumar Buddha. Baki khine sab ho hai ke? Admit call for the LCR. Or
notice.
Notice. Huh? Not first to 12. First to Devanga Hall. Serial number 37. DK Buddha.
2. Item 2.
Item number 2. (302) এটো পক্সো নহয় এটো নোটিস না লাগে নোটিস না লাগে হ্যাঁ এটো আইটেম সিরিয়াল নাম্বার 17 নবনীত কুমার বড়ুয়া এটো পক্সো নাছিল হ্যাঁ এটো 302 এটো Atal Tiwari number 7 serial 7
Item 4.
My pleasure, Lordship. When the appellant is subjected for life on the
302 it will have Anuddin 302,
Secret.
Madam A. Begum. So good taken 6 weeks, okay? You have an IA for suspension? I
Yeah.
had noticed it, I had 6 weeks.
Obliged.
LCR. After LCR.
After LCR. Admission to LCR থাকিব admitted to call for the LCR থাকিব
Identify.
5 is POXO 4,
Oh, yes,
20
POXO.
years.
20 years.
POXO AM Ahmed admit করে দিব আৰু respondent state to প্ৰথমতে হেৰি APP আৰু respondent number 2 steps in the manner prescribed normal যোনটো থাকে POXO ঠিক আছে 6 weeks for service report as well as the report of LCR notice you have filed this IA for suspension
Yeah.
I notice the
File my objection.
okay objections if any into last of
Perfect.
maybe file in the meantime
Obliged.
Item 6.
660 state appeal against acquittal, Your Lordship. They have filed
May-
an objection.
regarding the leave
Condonation is done. There was a delay of 58 days. Now the leave petition is before Your Lordship. They have filed an objection.
Yes,
as
yes,
far
I
as-
file objection. My lord, my senior is arguing another foot. Can you pass over for 5 days?
Objection I have not gone through, neither it's in my file. So let. it
when
be
did you
taken
file the
to-
objection
Get the objection.
is on record is on record it's on record
Put in the file. but
it is
your
on it
office
is on
people-
record on a joint request made on behalf of the parties matter is adjourned to be listed after a week
Lord. Discuss file.
Obliged.
7.
Seven.
এইকেইটাই নেকি? supply list নাই নেকি? surveillance ৰ লম্বা আছে আৰু মোৰ certain এখন হেৰিও আছে মোৰ interview আছে
Good. No.
আজি কালি পৰহি 3 দিন yes next Mr. Deuri
Not here.
P. Deuri R. Chetri and Mili and the other matter other one as what Hakur
My objection is there on record. I filed it. It is a POXO matter on the
I for suspension. None appears for the appellant on call, whereas Miss Ed Jahan Leonard APP Assam, who is present, submits that the objection has been filed. Para, in the interest of justice, list after a week.
Item 8.
Item 8,
The condonation is on record. Lord. Before it.
first time it has come.
And the condonation delay is yet to be condoned.
Item 8, who is for item 8?
Yes. 8, yes. You're there.
You're for item 8.
Yes, madam. I'm legal aid counsel.
Okay. What is this IA for?
This IF for condoning delay, my lord,
How many days?
and there has been a delay of 343 days, my lord. There has been no negligence on the part of the petitioner.
Okay. Your name?
S. Mehti.
Heard Miss S. Mehdi, Learned Legal Aid Counsel, appearing for the applicant
Yes, my lord.
who has filed this application under Section 5 of the Limitation Act 1963 for condonation of delay of 343 days in preferring the connected appeal. Full stop. The appeal has been preferred against so-and-so, likhi diba, pura. Issue notice returnable by 6 weeks. Para, Ms. Ad Jahan, Learned APP, accepts notice on behalf of respondent number 1, Tate. That steps be taken for service of notice upon the respondent number 2 in the manner prescribed through the office of the public prosecutor Assam. steps within 2 days.
Highly obliged, sir.
এই আমার AM ডট কম যে আছে সেইটাও বহুতখিনি হেৰি দিছিল citation আমি এনে ৰাখিলে আমাৰ বাৰ্ডেন পৰিলে আপোনাৰ তেওঁ
Petition, maintenance. But. This matter come
what
up,
stage?
in the meantime, respondent wife,
Okay,
Maybe-
where does
Okay.
the other one?
one matter.
1 minute, okay. Where does
May I please, your lordship, lordship, I beg to mention item number 18, lordship.
yes,
In this case, what has happened, lordship, the other co-accused
Hmm.
have been granted bail by another court. Another honorable court, lordship. So the matter may be listed before that appropriate court.
why?
There is Supreme Court judgment, lord.
Is it?
If rejected by the same judge, lordship.
Not
or
reject, he said allowed,
Fire it same and allowed it also, but
allowed.
whatever I know. But
Okay, okay, do you have the number?
Lordship. Reject, allowed,
Yes, yes.
yes.
Sri P. Bordoloi Learned Counsel has submitted that a co-accused in the same case has been granted bail in
AB number
AB number
2365,
2365 or 24
24, lord.
by another bench of this court. Beckett, which court?
Honorable Justice Mridul Kumar Kul.
Honorable Justice M.K. Kolita. Full stop. He has submitted that as per guideline, as per a directive of the Honorable Supreme Court, such matters are to be listed before the same bench.
Lordship.
Full stop. Para. Registry to verify and list accordingly.
But if it is available, it needs to be retained. It is available.
The CD may be retained till such consideration.
Lordship. Obliged. Lordship, interim order.
Interim order passed earlier to continue till the next date of listing.
Obliged.
May I please, your lordship, I beg to mention item number 17 of the date.
Yes.
In this matter, lordship, it is not received, lordship, but matter may be accepted.
Yes, Mr. Das.
It is not received. One
Which-
data
which-
and another.
Which PS?
Patsala PS, Patsala.
Patsala, why not?
They asked for another date, lordship,
Mhm.
due to.
On a prayer made on behalf of, made by Sri K.K. Das, learned APP, Assam. Matter is adjourned to be listed on
Patsala. 19, lordship.
To be listed on 19th of November to enable him to obtain the case diary. There is interim order.
Yes, lord. Okay.
Para interim order stands extended till the next date of listing. 1911 will have for CD.
Same, lordship.
Yes.
May I please ask you, Lordship? Lordship, I have a prayer for listing of a matter pertaining to single bench Honorable Justice Vijay Soitia. This
You want listing? What is the matter about? New matter?
posting of court FIR.
What is the stage?
There is no stay.
What is the stage of the case?
Your Honor, the next date of trial court in 14/11 of this month and necessary order for.
14/11. Okay, we'll have it on 13, the Wednesday.
Lordship, I beg to mention item 16.
Yes,
Lordship, in this matter, Mr. K. Borua has been newly engaged and currently he is out of station. Therefore, it may be fixed on 14th.
have you
As-
informed the other side? There's
Lordship,
the informant has appeared, P. Neog. You inform him. Then you make a mention, we'll accommodate. Okay?
obliged.
May I please, your lordship? Your lordship, I beg to mention daily list item number 7.
Yes,
Engaged counsel S.A. Boruya is seriously ill, your lordship. May be fixed at any other date. Item number 7.
item 7, Mr. PP, 7. On a prayer made on behalf of the applicants. List after a week?
Indeed.
Yes. CD may be retained.
Much
May it please my lordship, there is a withdrawal pertaining to matters assigned to the single bench of Honorable Mr. Justice P.J. Saikia. Criminal petition number 558
When do you want to,
of
when do you
2020.
want the listing? Day after tomorrow?
Sir, tomorrow.
Tomorrow, withdrawal. Day after tomorrow, have it on Wednesday. Tomorrow it may not be possible. Okay.
Thank you.
পাৰিব নেকি tomorrow? Okay, tomorrow, give tomorrow's date.
Your Lordship, I beg to mention case number, criminal petition 143, 2024 for listing.
What is the stage?
Your Lordship, it was last listed on 12th February 2024 for motion.
What is the case about?
It's a case about the family FC civil court. And DV case number 219.
Friday.
Friday. Obliged.
May it pleases your lordship.
Yes.
Lordship, I beg to mention item number 4 of the daily list.
Yes,
Lordship, may the matter be adjourned for the day as my senior is out of station today.
okay. On a prayer made on behalf of the applicant, list on Wednesday,
Deeply
day
honored.
after tomorrow.
Item 1,
আজি এচিটো দিয়া নাই নেকি? অলপ পিছত বন্ধ কৰিব লাগে, এতিয়া গৰম হ'ব। Item 1. Bail application. None appears for the petitioner on call, whereas Sri K.K. Das, learned additional PP is present. Para. On the last two occasions also, that is 29/10/2024 and 4/11/2024, time was sought for on behalf of the petitioner. Para. Be that as it may, considering that the application is for bail, the matter is adjourned to be listed on Friday. Friday date, okay? Friday bond, okay, on 18th.
item 2,
May I please, Lord?
Yes, Mr. Khan, what is this? Bail.
My Lord, he is in Lordship jail for Lordship last 15 days. FIR is at page 7.
Page 7.
On, my Lord.
Please read.
With due respect, back to state that on last night, as per GDNP number so dated so while I along with my staff so were in patrolling duty at so night, one Bolero pickup registration number so was coming from West Bengal towards Guwahati and stole the vehicle at Aunguri village at so highway, national highway, and noticed that a lady was forcefully picked up in the vehicle. And I proceeded towards them to know about the incident. The vehicle ran with high speed. At that time, although I gave a signal to stop the vehicle, but the vehicle fled by dropping the lady forcefully. Thereafter, with the help of police of Kariga and
You get the case there.
Lord.
Heard. Three. M. Khan, learned counsel for the petitioner who has filed this petition under section 483 of the BNS for grant of bail in connection with so-and-so. Call for the, this is Safrangudi.
My Lord.
Call for the case diary. Fixing
21.
21/11. Sri K.K. Das, learned APP, shall do the needful.
item 3,
Yes.
May I please? Lordship, application under 482. So allegations are under 447, 376, 503, and 34 of Indian Penal Code.
Let us see.
Your Lordship may use the FIR, which is the page number 13, your Lord.
1-3.
1-3, your lordship.
Yes.
The lordship, the facts of the case is such that,
Now, please read it.
yes, your lordship.
Where?
Case number 13, the registered FIR and
Where is the Ajahar?
FIR,
Contents.
case 11, your lordship. That-
11 is the deposition.
Yes, your lordship. Actually, the fact of the case is such that the FIR has been registered on the direction of
What
the,
is your, what have you written in Annexure 1? Type 10?
your lordship.
Annexure 1, page 11?
Yes, your lordship.
What?
Typed and translated copy of deposition of complainant.
Deposition of complainant. What is this? Where is your Ajahar?
Actually, lordship, it has been registered. The FIR has been registered on the direction of the Lanet JMFC, lordship.
First, you had registered a complaint.
First, the complainant approached the
Court.
Yes.
So why have you written deposition? Okay, let us read your complaint. It's a complaint registered case.
Yes, lordship.
Yes,
Complaint.
please. Why complaint in a case of rape? Please read. That my husband is in Saudi Arabia, not at home, and I do-
Vernacular, no? Lordship, the victim respectfully submitted that my husband lives in Saudi Arabia. My husband is not at home and I live with my 3.5-year-old son at my father's house. The number one accused broke the door of the room where I was sleeping on 4/6/2024 at around 1:30.
What is the date of this complaint?
Your lordship, lordship, direction was passed on 28/9/2024.
Where do you get?
Lordship, that is on page number 19, lordship.
But where is the date in your complaint?
Lordship,
Lordship 4/6,
Where?
2024.
Where do you get?
11, Lordship.
Page 11?
Yes.
4/6/2024.
Yes.
Okay, and the occurrence was also on 4/6.
4/6.
4/6.
Yes.
No, that is not the date of the complaint. That is the date of the incident.
incident, lordship.
When was the complaint lodged?
Lordship,
While making the translation, why do you miss out the most important facts? Where do you get the date?
Lordship, 27/8/2024.
Where do you get?
Lordship, that is on page number 18, paragraph number 2, lordship. The
Page-
facts of the case.
Page
is that-
18.
Page 19, lordship, paragraph number 2, lordship. The facts of the case is that on 27/8.
Will you get the date of the complaint from reading another order? Where is the complaint in original?
Lordship, that I have not acquired, lordship.
You have not annexed.
No, lordship. Lordship, that's the order copy, lordship.
এইটো কেনেকে কৰিছে? এইটো আমাৰ ইমান বাৰ কৰাৰ পিছত কিয় কৰি আছে? Translate copy দিলে vernacular খন দিব লাগিব। How is it? How do you manage to get it passed? Where is the vernacular? Aren't you required to file the vernacular? Have you filed? Just check. This is at page 16, Mr. Counsel. Why don't you see? And it has not, just to be tagged together, not separately. Page 16 is the complaint, isn't it?
Yes.
You are not equipped. 27/8, it has been lodged. 27/8, it has been lodged.
Yes, Lord. Yes, Lord. And the order was passed on 28/9.
Yes, please read now. Please read the complaint at page 12.
Lordship, the vernacular one.
No, page 12. Accused number 1 broke. Accused number 1 broke the door of the room, third line.
Yes, Lordship. The accused number 1 broke the door of the room where I was sleeping on 4/6/2024 at around 1:30 p.m. The accused entered the room without our permission. Then he put some medicine on my nose and knocked me unconscious. He then grabbed me by my throat, dragged me about 300 meters from my father's house and took off my clothes and forcibly raped me against my will and consent. It was raining heavily at that time. I then regained my consciousness after feeling cold as rainwater fell on my nose and mouth. And I saw the accused person. I screamed loudly and then the accused left. I came home anyway and immediately informed my family about the incident. When my father complained, when my father accused number two ran my the accused number two is the father of the petitioner herein. Lordship. Ran my father away for killing him and insulting him. I lodged the written complaint with the Huragao police station on 5/6/2024 regarding the incident, but the police station did not register a case. Then on 11/6/2024, I filed a complaint with the office of the Honorable SP and forwarded to the Huragao police station, but no action was taken. The accused is making various threats to the victim. Therefore, the Honorable Court kindly requested to register the case under the above section and prayed for a fair trial of the case.
Thereafter, it was sent for investigation.
Yes.
You are named in the complaint, number one.
Yes, Court.
What is your explanation immediately?
Your
No,
Lordship,
we were concerned that why this complaint has been lodged after such a delay, but she says that on very next date she had gone to the police station, not registered. 11/6, filed a complaint with the SP, nothing has been done.
Yes, Lordship. Because there was no evidence on materials to substantiate her claims, Lordship. She had falsely implicated the accused petitioner because on that very day, that is on 4/6/2024, Lordship, actually on the evening, there were actually a quarrel between the two families, and moreover, the petitioner and the complainant herein are relatives. So they were in a quarrel regarding doing some fishing activities. So the complainant.
Yes, Mr. Das, what do you say? Is there, will definitely.
376 is there, Lord.
Huh?
376 is there. But
Did she speak about any medical? No, nothing. What is your name?
Lordship Ziarul,
Your name, your name.
Lordship Abhijit Chaudhary, yes, Lordship.
Heard Sri A. Chaudhary, learned counsel for the petitioner who has filed this petition under section so and so in connection with so and so. Huh? Call for the case diary fixing. This will come from which place? Murigaon?
Morigaon.
Fixing. The next date is 29/11/2024. Para. The learned counsel for the petitioner has submitted that though the offenses involved are serious in nature, a bare reading of the allegations which has been registered in the form of a complaint would show that the same are concocted. He has highlighted the aspect that though the alleged incident is of 4/6/2024, the complaint has been lodged on 27/8/2024. Full stop. Para. On the other hand, and on the other hand, resisting the prayer for interim bail, Sri Das, the learned APP, has submitted that in the complaint itself, necessary explanations have been given as to why the delay has occurred. Full stop. On consideration of the rival submission, on the aspect of the prayer for interim protection, this court is of the opinion that interest of justice would be served if an order of interim protection is passed in the meantime. Full stop. Accordingly, it is directed in the interim that in the event of arrest, so and so, arresting authority, the petitioner is, however, required to directed to appear before the IO, before the concerned Thana oblique IO on or before 22nd of 11, no? On or before 18th of November for recording his statement. Full stop. The petitioner is also directed not to temper. Okay. List on 29.
Within 5.
May I please, sir? My lord, here lordship will find, my lord, the affair at page, my lord, 8.
Page 8.
Page 8.
Yes, please.
With due respect, I beg to state that on Rashmina Khatun is my daughter named is so as at about 14 years. He did in class 7, 8. Last on 21/10/2024 at about 7 p.m. While my daughter went to my elder brother's house at the same time, the above noted accused person with the complicity of the other accused person kidnapped my daughter and brought to her to his own house. Thereafter, on the same night, at about 11:30 p.m., my daughter handed over to the Fakirganj police station by Anfazlur Rahman, PDP, Ranipura village. Later on, some family members of our family went to the Fakirganj police station and picked up my daughter from the said police station. Therefore, Your Honor would be
Yes.
placed in case.
Without consent, they have taken the.
14-year-old.
Yes, 14 years. Now, Lordship, kindly see paragraph 4, my lord, we have explained the my lord, situation. She came to our house and insist to solemnize the marriage, but the parents of the my lord, petitioner advise her not since they are minor. Both the boys is 19 years and girl is 15 years. My lord. Ultimately, my lord, she has been recovered. She was handed over to the Fakirganj police station by the petitioner's parent. My lord.
No, by the VDP.
By the VDP as well as the petitioner.
Where?
That is the allegation, my lord. My
Where?
lord, we have explained, my lord.
No, where is in the FIR? It has not been lodged. It has not been stated. It only says that we have read this one by one. Fazlur Rahman, VDP.
That is the my lord, affair, my lord. Lordship, kindly see paragraph 4, my lord, of my petition.
No, that is your explanation.
Yes.
If your parents
My lord.
would have handed her over
Yes.
either to the Thana or back to her family, matter would have been it's by the VDP.
VDP, because my lord, some extraneous consideration, the VDP person.
Yeah, the
insisted-
victim's statement recorded.
I think, my lord, recorded, my lord.
Who are you?
The my lord, my lord, petitioner, he is the my lord, boy who had a law papers with the victim. Boy is 19 years, my lord.
Yes.
And they are the student of same school, my lord.
If the statement will be get lost, it will be better lost.
Okay. Heard 3 MU Mondal, learned counsel for the petitioner who has filed this so and so, under so and so. Call for the case there. Which Thana? South Salmara.
South Salmara.
Call for the case diary listing, the case diary fixing 29/11. 29/11, bring it.
Look.
Not 29, I will give a early date. Which date, Mr. Das? Tell us.
Lordship, 22nd.
22nd, okay. No, let it be 29th. 29th November 2023. Mondal, learned counsel, prays for an interim protection. Full stop. By drawing the attention of this court to the statements made in paragraph 4 of the petition, the learned counsel has submitted that the victim girl had come to the residence of the petitioner on her own volition, as both of them are from the same school and were having love affairs, full stop. However, the parents of the petitioner and some elders of the village had handed over the victim girl to the concerned PS. Full stop. He has also submitted that there is no allegation of use of any force or any other aspects. Para. Sri Das, the learned APP Assam, has however resisted the prayer for interim protection by submitting that the victim is a minor and the allegations are serious in nature. Para. After considering the rival submissions, this court is of the opinion that interest of justice would be served if some interim protection is granted. That's what I can. Accordingly, it is directed in the interim, same order. Okay. You appear
Well.
on or before. On or before 18th. We are fixing on 29th.
Leave law pledge.
6, I think 6.
Mayor, case 36 submitted. But the petitioner behind the bars last on 510. Well, can have a look at page 7. Well, page
You can apply for regular bail.
regular when matter due to my lord is a case, my lord, based on the section 1182, my lord. My lord, the magistrate has no power to grant. I have to, after committing the my lord case, my lord, I have to come to the my lord,
Who
decision.
says the magistrate does not have the power?
No, my lord, Mr. has not, my lord, never entertained my lord.
No, who says?
No, my lord, this is a general practice, my lord. I have so many experience in this.
If you're a lawyer, you have to show
No,
the
no,
law.
no, my lord, I have so many experience. Even some, my lord, magistrate.
Why don't you show the law to the learned
No,
magistrate?
no, they are reluctant, my lord.
Reluctance is a different matter.
My lord,
See, not
because there is a
exercising
case, my lord.
power and not exercising power
Right.
and saying that I am
But-
not vested with the power are different matters.
My lord, the magistrate
See,
has
these are
the
discretion-
impression that, my lord, that is, when the case is triable by the decisions, my lord, then it is not, even my lord, kindly have a look at page,
Mr.
my lord, page
Khonikor,
2,
Mr.
my
Khonikor, as a lawyer, kindly argue as a lawyer. See, there are
no, your
powers.
lordship, even
See,
your lordship, my lord.
It's a matter of discretion.
Right.
Exercising, not exercising discretion is a different aspect altogether. But saying that I do not have the power and jurisdiction, that's a different matter. Show the law to the learned magistrate.
Even when they commit, my lord, they commit the case, my lord, and send to the, my lord,
After
Yes,
committal of the committal order is passed, we are not on that. We are on a stage before the committal.
but they are not entitled, my lord. Even I have, my lord, so many experience in this regard.
No, where is the order? Kindly show us the order that he doesn't have the power.
No, there is no.
No, has he
Even
passed any-
Supreme Court says that, my lord, he has the power.
No, then you show it to the learned
But
magistrate.
even when your laws, when this is my lord, Sasti has been submitted, my lord, then your lordship has already, maybe, my lord, gone bail, my lord.
What are the
But
offense?
no, my lord, there is no required, no necessity.
What is the offense?
Offense, my lord, 118, my lord.
No, let us see the allegation.
Allegation. This is, my lord, page, my lord, 7. These are all police persons, my lord. There are 3 police persons, my lord. They came to the restaurant, my lord, and some altercation took place, and my lord, this petitioner is behind them.
Please read.
With due respect, this is to inform you that on 4/10/2024, I, along with the driver of Dhokahona PS, namely Midul Hazarika and Lansnack Vipulnath, went for dinner at Ramdhanu restaurant situated in Duliagaon. In that said restaurant, the aforesaid second party were making halla, and my staff, Havildar Midul Hazarika, asked the second party not to make halla. However, the second party tried to attack with sharp weapon with Midul Hazarika. When I resist him, then the second party attacked me with sharp weapon, resulting in which I sustained injury. These are all police persons. Even when kindly have a look at
You
page
have
10.
CD. Your charge, get the copy.
Well, page 10, kindly have a
Because
look.
of the record, we want to see the medical. Use of sharp weapon, what kind of injuries?
Well, reasons for arrest, man, kindly have a look. There is no mention, man, that he has sustained any injuries.
Let us see.
Well, page 10, man.
You got the medical report.
Can
copy.
Now, my petitioner behind the bus, my lord, 510, my lord. Already, my lord, submitted, my lord.
Let us
No.
see. Let us see what is there.
Page 10.
You are behind the bar since
Since, my lord, 510, my lord.
5:10. Today is what? Today's matter, 11.
11.
More than using of sharp weapon on your colleague.
But this is not sharp weapon, my lord. I have categorically stated in my
That-
petition, paragraph 4, my lord.
That is your allegation.
Paragraph 4, my lord, what is
that is
the
your-
real facts, my lord?
that
Even,
is-
my lord,
That
even
is your
my-
explanation. Let
my
us
lord,
see
even my lord's ground of arrest, my lord, there is no mention that he was sustained any injury.
No, ground of arrest is injuries mentioned.
No, my lord, not a single whisper, my lord, that he was
So
sustained.
is it required that you mention injuries also?
But even, my lord, kindly have a reason for arrest, my lord, kindly have a reason for arrest.
No, on the earlier occasion, what did you do, Mr. PP?
My lord, this is the second time, my lord.
Call for the case diary,
Right.
call for the. On 22/10, it was
Right.
called for. You get the records, scan. What do you get? Scan copies, scan copies,
By the registry, Lord.
because it has been, you have said that it's with, charge sheet has been filed before it's in the court.
Lord,
We'll get a scan copy of the,
to registry, Lord.
to the registry.
Even, my lord,
Which one, which court?
my lord, Dhoko, my lord, SDGM Dhoko.
You
Well,
could have got some instructions on the aspect of injuries sustained.
That will, my lord, that will.
I think that is
That-
the only
that part-
consideration part. Otherwise, in face
I have categorically stated that, my lord, he has not sustained injuries. Even I sustained injuries.
We heard 3A Chronicle learned counsel for the petitioner, who has informed that in the meantime, investigation is over
Right.
and the charge sheet has been filed. Full stop. He has
No,
also,
I have not informed. He has stated.
you have not informed.
No, he has
Okay,
committed a
okay,
such.
okay. Don't say, say Chronicle learned counsel, who submits that the petitioner is in custody since
5-10, 6-10.
6/10/2024, and the and in the forwarding report, there are no discernible and serious grounds. There are no serious grounds
No.
of arrest. Full stop para. Reading of the FIR would, however, indicate that there was use of sharp weapon causing injuries. Full stop. Accordingly, this court is of the opinion that the materials pertaining to the same are required to be looked into. Para. Since Sri K.K. Das learned APP para has submitted that charge sheet, that investigation is over and charge sheet has been filed, registry to requisition a scan copy of the materials which have been filed before the, which court?
SDGM
Before
Dhoko.
the concerned court, namely
SDGM Dhoko.
Dhokwa. Full stop. The requisition be made urgently and the case be listed for consideration on we have it on 20th. Just a week, next Wednesday, 20th.
Well, my lord, the tier number may be recorded, my lord.
Charge
Charge sheet
sheet number, Lord.
Oh, yeah.
That's my lord, it will.
66
Being
oblique
charge sheet,
20
being charge sheet number
66/24 dated 30/10/2024.
Visa. Okay.
Deep lord.
Item 8. Case diary, receive the case diary.
Charge sheet submitted, Lord.
Or again, none appears for the petitioner on call. Para. Do by the order dated 29/10/2024, the case diary was called for. Sri K.K. Das, learned APP, has informed that as per instructions received, the charge sheet has been submitted. Para, in the interest of justice, list on Thursday. Bail, okay. Thursday, date, it Thursday. Friday, bond house. 14th. Item 9.
May I please, okay. Well, in fact, today, today we do not require to appear, but if you lots of kindly see the last order, 25th October. Finance Council is just has withdrawn his name from the case. Accordingly, it is allowed.
City notice.
Interim bail has been cancelled. Has he appeared? No.
Last,
Updated city notice.
Huh?
Updated city notice.
and as per the order of 25th October, the registry has already sent to the notice.
Notice.
Office note 30th October 2024. But no report is. So Lana Council is on leg. He has already withdrawn his name.
Okay, doesn't matter. As per office note dated 30/10/2024, notice was issued to the petitioner pursuant to the directions dated 25/10/2024 of this court. There is no further, there is no, till now the registry has not received any response thereafter. Sarah, in the interest of justice, matter is adjourned to be listed after 2 weeks.
Item 10.
First is submitted. May I please?
You appear? Okay. Which court?
For Bataman.
Heard your name?
H. Ahmed.
Heard Sri H. Ahmed, learned counsel for the petitioner who has filed this application under so-and-so in connection with so-and-so. Para, wide an order dated 30/7/2024. This court, while calling for the case diary, had also passed an interim order which is in force till which is in force till date. What's the para? Sri K.K. Das, learned APP, Assam, has however submitted that as per instructions received, the charge sheet has been filed after completion of the investigation. Para, in view of the aforesaid development, this court is of the opinion that the petitioner is required to appear before the learned court, namely CZM Borpeta, and pray for regular bail. Full stop. Accordingly, the bail petition is disposed of by directing the petitioner to appear before the learned court, before the learned Chief Judicial Magistrate Borpeta within a period of 7 days from today. Full stop. It is also directed that in the event such appearance is made within the aforesaid period of 7 days and an application for bail is made, the same would be considered until such consideration, the interim protection passed by this court would continue.
Circuit number.
Give the number, please.
Circuit number 97/2024, dated 30/8/2024.
Oh,
Right.
disposed of, huh?
11.
Yes.
On the last occasion, the up-to-date case diary was called. Now, in this particular case diary, I see there is only one stipulation on the last stipulation on 1st of September 24, saying that he is yet to be arrested. I mean, they did not find him in his house address.
My lord, may it please your lord, my lord. 16 is the FIR, my lord, page 16,
This is an anticipatory bail.
anticipated bill, my lord.
Case diary called for.
Case diary is here. This is embezzlement of money from a bank.
Then you can consider the case diary and decide.
He is the cashier. Other materials are there against it.
What more materials was the,
The witnesses have stated that he.
no, you said that we wanted to have some more updated.
On the last occasion on 20th of September,
Yes.
up-to-date case diary was required. It was sent back and to be submitted again. Now here there is only one page, right? 1/9, and saying that he is not found in his house. In his home, at his home.
Yes, Mr. Hazarika, what is this?
My lord, here petitioner before lord is a cashier, my lord, of a bank. It is admitted, my lord, I had knowledge about it. Because, my lord, I had done this, I tried to explain at para 3, my lord, what is the reason, my lord, of doing
What
that.
is the amount involved?
Amount is 13 lakh.
And on the day when he admitted that he had taken the money, he had taken some more money as well. He fled from the scene and he is nowhere to be found.
My lord,
What is your age, Mr. Hazarika?
my lord, there has been, my lord,
Age?
Sir.
Family man?
Uh,
Huh? Are you a family man or not?
41, my lord. 41?
May not be a fit case for consideration, AB.
There was an inquiry made and in the inquiry also it was found.
Why are you absconding?
My lord, waiting for this particular application outcome.
With
My
nature
lord,
of-
only thing, my lord, I will lose everything, my lord, job and everything. That is,
Yeah, that,
yes, true.
that you should have thought of.
my lord, can it be this way, my lord? Kind of good. My lord, he will duty bound. He will appear, my lord, before the police.
You appear,
Yes.
that is already there. You appear, you pray for bail.
That is the only thing left.
Heard, Sri T.H. Hazarika Learned Counsel for the petitioner. Also heard, Miss S. Jahan Learned Additional PP, Assam. Full stop. Pursuant to orders passed by this court, the case diary has been received. Full stop. Para. The allegation against the petitioner, who is a cashier, was a cashier
Yes.
in the Assam Gramin Bank, Gramin Vikas Bank. Which branch?
Dhola.
Hola.
Thola. Is with regard to defalcation of
11
money.
lakh.
Total is, my lord, 13 lakh
Of
86,430.
money from the bank amounting to rupees 13 lakhs approximately. Full stop. In the FIR, it has also been stated that when the matter was detected, the petitioner was found to be absconding and his whereabouts were not able to be located. Full stop. Para. Sri Hazarika, the learned counsel, by referring to the averments made in paragraph 4, paragraph 3
Yes.
of the petition, has submitted that there are adequate explanation of the entire matter. And he has no criminal intent to defalcate.
My lord, my explanation is this, my lord. This has been done by the manager. But I have stated that one Raju,
Yes.
Raju Doimari, my lord, he has misappropriated, my
No,
lord.
no, you do not have any intent. There, কি করলো উপরে? আমার এখানে না টারা করতে লিখলে। He has explained. And no matter wherein the petitioner has tried to implicate the branch manager for the entire offense. Full stop. He has also submitted that the petitioner is not involved in any misappropriation. Para. Ms. Jahan, the learned APP, has however submitted that the materials in the case diary would indicate the involvement, would prima facie indicate the involvement of the petitioner, who was the cashier of the bank. The further aspect that till date the petitioner is absconding would also go against the petitioner. Full stop para. After submission, after consideration of the rival submission and on perusal of the materials in the case diary, comma. Kindly, can you pass on the case diary?
The marked portions are the witnesses.
This court is of the opinion that the present may not be a fit case for exercise of discretion to pass an order of anticipatory bail. Full stop. Accordingly, the petition is dismissed. Full stop. At this stage, the learned counsel for the petitioner submits that he may be given liberty to appear before the learned court. But court where?
Yes, sir. Jurisdictional court, my lord.
No, investigation is still on.
Zero.
Appear as what?
My lord,
Yeah,
actually,
for
he
the
wanted to surrender before the.
You have to appear
Wait,
before the police. Where? Don't write
Well,
this.
this line not required.
Not required.
Not-
If charge sheet was submitted in the
Yes,
meantime,
then
then
what?
matter would have.
Unless
Case
still-
diary returned here with.
Obliged, my lord.
Last call ko na rakhe, at this stage na rakhe.
Item 12.
It said it's not there. But
Mr. Dave, what is this?
Lordship,
Get the case diary, this AB.
AB Lord.
it is not.
Boundary dispute was there, Lordship, and both are family members to Lordship.
Our intimation had gone, but then it is not received. They
Get the case diary.
Lordship, in para 3 and 4, Lordship, I have mentioned everything, Lordship. Can it consider interim period?
Interim first date was not considered.
Not.
How do you consider now? Let us see the allegations.
Lordship, page, FIR page 9, Lordship.
9.
9. With due respect, married
What is your name? Pradut
Pradut, Lordship.
and Prabhut.
Yes, Lord.
2 persons.
2 persons. 3
Brothers.
persons is there. Papan Dhori is there.
Papon.
Papon. Papon is not before Lordship.
You are from whom?
Pradut and Prabhu.
Okay.
With due respect, I beg to submit that I am Nirupam Dev, lived in my workplace at Kathigora Park on 23/5/24 night at about 10:30 p.m. Above mentioned accused person attacked my brother Pinak with sharp dao and rod. Kill him near Kalbat of Harinagar, Kinnokal Pitavur Road. He was assaulted by rod and dao for previous injuries on his head, leg.
Oh, so
And-
allegations are serious.
So
We
many-
thought you said boundary dispute. You get the medical
Not-
report also, okay? Injury report, it's been called for, okay.
it has
Though case diary along with injury report was called for, comma. Ms. H. Jahan, learned APP, Assam has submitted that those are yet to be received. Full stop. On her prayer, matter is adjourned to enable her to obtained the same, full stop, list on Katigora, list on, when? 21st,
21st, not, it's 21st.
21st.
Okay.
Okay, next.
Item 13,
There also we don't have the case diary.
I think last occasion. May please hold. TRS bail application lordship. On last occasion, final postmortem report was called
Ah.
for.
Now, what had happened is that the postmortem report, the report was kept pending for FSL report. And the FSL report said that there was no poison in the body parts. Now, the final postmortem report is not here. Police said that they could not collect it. Perhaps it is not prepared as well.
If you have the FSL separately, is it required? We don't.
No,
It
this
only,
is-
it only be a combined thing.
Hmm.
Allegation of what?
FIR is at page
Yes,
9
sir.
lordship,
What is the allegation?
providing excessive amount
Ah,
of drugs.
right.
That is, there is
Possibly
there is no direct
administered.
allegation against us lordship. Here, the informant specifically mentioned the FIR that accused number 3, 4 and 5.
Please read. Please
With due
read.
respect, I would like to bring your notice that the accused mentioned above are drug dealers. The first accused has been involved in drug trafficking for the past 4 years, due to which the youth and school students of our village have started consuming drugs. Although we, the conscious public, have tried to stop them and have lost several complaints at the police station. The accused have continued to supply drugs worth lakhs of rupees, disregarding the community. Among them, on 26/07/2024, while I was not at home, the third, fourth, and fifth accused lured my minor son so-and-so with money and took him the house of the first accused, where they made him consume an excessive amount of drugs. As a result, my son fell unconscious at the first accused house. He was immediately taken to Gorimari Community Hospital, but he died on the way. This is the allegation, lordship. There is no direct allegation against us. We are accused number 1 and 2. Here in the FIR, the informant specifically mentioned that on 26, the accused number 3, 4, and 5 induced the minor son of the informant, lordship.
And they lured and took him.
Who are you?
The first Maharali and wife of
We
Maharali.
are husband and wife.
What do you do?
Look.
What do you do? What is your business?
Lordship, we are daily wage labor, lordship.
Daily
That
wage-
is-
At the
Huh?
It is alleged that they are the drug dealers.
Do you have anything?
And we have the case diary, the witnesses have stated that they were continuing with the drug business since long. And they even say the son was also a drug addict
Who has died?
who died. And then they took him to the hospital. On the way he
Not a
died.
case for AB. Not a case for AB.
302.
What is your name?
Anjaman.
Heard Sri Anjaman, learned counsel for the petitioner. Who has filed this petition under section so and so in connection with so and so. Petitioners, Duta. Also heard Miss S. Jahan, learned APP Assam, who has produced the case diary along with further information. Full stop. Para. The allegation against the FIR is connected with the death of the son of the informant by drug overdose, by use of drugs, by use of drugs which were administered by the accused persons. Full stop. The learned counsel for the petitioners has however submitted that the allegations are not against his clients,
Yes.
but the accused numbers 3, 4, and 5, who had lured the minor son and made him consume excessive amount of drugs. Para. On the other hand, Ms. Jahan, the learned APP, has submitted that the materials in the case diary would reveal that the petitioners are also in the illegal business of drug trafficking. Full stop. She has submitted that though the forensic report which has been obtained after the opinion was sought for in the PM report suggests that there was no poisoning, comma, the aspect of the allegation cannot be would not stand diluted, as the same is, as the allegation is not of poisoning but of abuse but of drug abuse.
In the postmortem report, it is written that fraud was found and his nails became blue.
Okay. Para, considering the nature of the allegations and also the aspect that the and also considering the seriousness of the offense, comma, this court is of the opinion that the present is not a case for grant of anticipatory bail. Accordingly, the same stands rejected.
Blacks.
Case diary returned.
14.
Case diary is not here.
None appears for the petitioner on call. Para. In the interest of justice, list on 18th. Which Shana, madam?
This is Kamrup only,
Which one?
this is Soigaon.
Sorry. Ms. Jahan, learned APP, shall obtain the case diary.
On 18 lot.
18th.
15.
CPI.
CBI.
Please, your lordship, I'm appearing on behalf of my senior Manoj Salwe. My senior, like on court number 20, kindly pass what I'm saying.
AB. AB,
Hello?
Mr. Sharma. AB.
AB.
For what is the offense?
Offense was not that online trading, but she is the mother of the accused. Accused means whatever in the FIR, 2% named, the main Dipankar.
Let his senior come
Let me take the 2, my lord. I will do other cases.
at 2.
Yes.
At 2, if we continue,
My lord.
we may not continue till 2.
So,
We don't have much matters, only 2 more matters.
Hello?
We only have 2 more matters. We'll have it tomorrow. Supplicate us.
Yes.
Duta has.
Oh,
But
tomorrow.
tomorrow, okay? On a prayer made on behalf of Sri M. Haloi, Learned Council, appearing for the CBI. Matter is adjourned to be listed tomorrow. Etu sonkale mari dibo.
Sixteen.
16, you had made a mention.
Yes, sir.
P. Neog, who's P. Neog? Not there. Okay. On a prayer made on behalf of the petitioner, matter is adjourned to be listed when?
Lordship on 14.
Listed on 14th, okay.
Take your right.
Yes, case diary is there.
Is it there, Lordship? I want to state that updated need to be there. Especially one report is there.
We'll
Lordship.
consider on the next day.
Okay, Lord.
Sri K.K. Das, Learned APP, is to retain the case diary.
Item 19.
It's not here again.
19 offense under?
My lord, offense under section 140 clause 3 BNSS, offense of kidnap, my lord. In this case, what happened, my lord? There is 2 petitioners who are the neighbors of the FIR name accused.
411 case diary was called for. We can have the look at the case diary.
My lord, just for a moment, please say the FIR page 10, my lord.
See, it was not granted on the first. Some interim measure granted is the effect, whereas one has been already been granted.
Yes, one was granted, my lord. Another is, Swan is the petitioner number 1, my lord. There is a father and son, and both are not belongs to the accused family and not related to the accused family. That they are neighbors of the accused family, my lord.
This is Horolumo PS. I
Horolumo-
can get it within 3-4 days.
On Thursday.
Thursday.
Okay. Case diary not received. full stop, on the prayer of Miss S. Jahan, learned APP, list on 14th for production of the case diary, which relates to Bhorolomukh PS,
Yes.
Guwahati.
Interim order,
Interim, there's no
earlier one, accused in respect of accused number, petition number 1.
interim order in respect of a petition number 1. Change extended till the next date of listing.
Most of them.
Item 22 supply list.
Yes, 22, yes.
First of all, for typing lordship.
Timing is difficult. What is the matter, AB? PP, we have got the say case diary.
Murder is there.
Huh?
Murder is also
Murder.
related to land lordship for document, but in
We'll
the
have day after tomorrow, okay?
Okay.
On a prayer made on behalf of the petitioner, matter is adjourned to be listed on Wednesday. Para, Sri K.K. Das Learned APP submits that case diary has been received. Full stop. The same be retained till the next date.
Apply.
Item 20 and 21.
23? Yes. I think Mr. Nayak has an application.
Yeah.
Representation of people. Sir.
but may I pray for some time, Lord, because senior advocate is appearing, Lord, please on lakes in another.
Okay, we have one matter there
No.
thereafter. Okay. But please call him because we do not have any other matter.
Item 23.
Yes,
May I
madam.
plead the Lord. Lordship, this I has been filed for correction of the typographical error in the order dated 38/20.
This court's order,
Yes, Lord. Lordship will find the order from page 8.
page
Page 8. It starts from page 8,
8.
8. But the
Eight.
relevant part is in page number 10. May I read it? Last correct.
Yes.
Sri D. Bora, Learned State Council, accept notice on behalf of respondent number 1. Sri R. Borpuzari, Learned Setting Council, Finance Department, accept notice on behalf of respondent number 2. Sri T. Deori, Learned Setting Council, APEPFO, accept notice on behalf of the respondent numbers 3 and 4. And Sri A. Ganguly, Learned Standing Council, PNB, accept notice on behalf of respondent number 5. Lordship, instead of respondent number 5, it should have been respondent number 6.
Okay.
And coming to the last part, Lordship, petitioner to take steps for service of notice upon the respondent number 4 by registered post with AD. And here, instead of respondent number 4, it should have been respondent 5.
5. Okay. Yeah, to have it, huh? Okay. Anyone? Who's there? Okay. Heard. What is your name?
A.N. Hussain on behalf of ASBA.
A.M. Hussain.
A.N.
Heard Miss A.M. Hussain, Learned Counsel for the applicant.
Yes, Lordship, the
Applicant,
applicant.
petitioner, applicants, public petitioners, who by means of this application has prayed for some typographic correction, has prayed for correction of some typographical errors appearing in the order dated 38/2024, by which notice was issued. Full stop. It is pointed out that in the portion of the order pertaining to acceptance / service of notice, there has been some error has crept in. Full stop. She submits that Sri A. Ganguly Learned Standing Council, PNB, should have been shown as the counsel for the respondent number 6 and steps for service of notice which was directed upon respondent number 4 by registered post with AD should have been in respect of respondent number 5, as respondent number 4 was already represented by the standing council. Para. The said prayer, the said contention has been examined. What's the para? Examined and found to be correct. Full stop para. In view of the aforesaid, in view of the above, comma, the order dated 38/20/24 stands corrected by directing that Sri A. Ganguly Learned Standing Council, PNB, would directing that the appearance of Sri A. Ganguly Learned Standing Council, PNB, would be in respect of respondent number 6 and the steps for service of notice which was directed to be taken by registered post with AD would be in respect of respondent number 5. Full stop. I accordingly stands allowed, and today's order be read as a part of the order dated 38/20/24. Para. Petitioner is accordingly directed to take steps for service of notice upon the respondent number 5 by registered post with AD within 2 days. List, the writ petition may be listed after 6 weeks along with service report. Is it one period?
It is still on TikTok.
You start, let him come.
If lot permits me, lot will pick up this matter after 5 minutes break.
Why not take a break? Why should I take a break at your concern? You start, he'll carry. Very like represents the way. Three 340 is your application.
Yes, lot 3340 is the latest application.
Under 86.
Yes, it is under file under section 86 of the RTA.
Let us see what is 86.
Trial of election. Trial of election petitions 1. High Court shall dismiss an election petition which does not comply with the provisions of section 81 or section 82 or section 117. Explanation: and order of the High Court dismissing an election petition under this subsection shall be deemed to be an order made under clause A of section 9A. 2. As soon as may be after an election petition has been presented to the High Court, it shall be referred to the judge or one of the judges who has or have been assigned by the Chief Justice for the trial of an election petition under subsection 2 of section 8A, where more than one petition Lordship, I am not going to other parts, Lordship. For me, Lordship, section 86(1) is sufficient.
Let my
No,
friend
no, no,
proceed.
you come. We have just starting with the provision. What is 86? Let us first understand.
86(1),
Yes.
trial for election petition. I'll go to that.
No, this is
Okay.
the start. We have just started.
The trial for election petition,
Hmm.
section 86.
Yes.
Trial for election petition, 1, the High Court shall dismiss an election petition which does not conform,
Comply.
which does not comply with the provisions of section 81 or 82 or 117.
Hmm.
Explanation. An order of the High Court dismissing an election petition under this subsection shall be deemed to be an order made under clause A of section 98.
That means the election petition has to meet the requirements of 81, 82
Or
or
117.
If
So
not,
our case is 81 and 81.
okay.
81. So may I go to 81 now?
Yes.
Presentation of petitions. 1. An election
Just a
petition.
minute. Just a minute. 81.
Yes, the previous page, Lord.
Presentation of petitions.
Yes. 1. An election petition calling in question any election may be presented on one or more of the grounds specified in subsection 1 of section 100 and 101 to the High Court by a candidate as such election or elector within 45 days, but not earlier than the date of election of the returned candidate, or if there is more than one returned candidate at the election and the dates of their election are different, the later of the two dates. That one is not real. Now coming to 3. Every election petition,
2 has been deleted.
deleted, Lord.
Yeah. Okay.
So 5 has come inserted with effect from 28th September 1961. Every election petition shall be accompanied.
Subsection 3.
Subsection 3.
Yes, please.
Every election petition shall be accompanied by as many copies thereof as there are respondents mentioned in the petition. And every such copy shall be attested, Lordship will kindly mark this word, attested by the petitioner under his own signature to be true copy of the petition. So that attestation has to be done. Now, parties, then content of the petition. Parties. 82, Lordship, parties to the petition. A petitioner shall join as respondents to his petition, where the petitioner, in addition to claiming a declaration that the election of all or any of the returned candidate is void, claims a further declaration that he himself or any other candidate has been duly elected, all the contesting candidates other than the petitioner, and where no such further declaration is claimed, all the returned candidates. And B, any other candidate against whom allegation of any corrupt practice are made in the petition. 83 now. This is also important here for our purpose. An election 1, 83 1.
Yes.
An election petition A shall contain a concise statement of the material facts on which the petitioner relies. B shall set forth full particulars of any corrupt practice that the petitioner alleges, including as full a statement as possible of the names of the parties alleged to have committed such corrupt practice and the date and place of the commission of such practice. And C shall be signed by the petitioner and verified in the manner laid down in the Code of Civil Procedure 1908 for the verification of pleadings. This is relevant for our purpose. So 83C is relevant for our purpose. B is also relevant for our purpose because we have taken that ground also that full particulars were not provided. And number 2, 81(3)
each election petition shall be accompanied as many as copies thereof are respondents mentioned in the petition, and every such copy shall be attested by the petitioner under his own signature to be true copies of the petition. True copies of the petition, that also Lordship will kindly mark. Now, this is the backdrop of the law. Now, under this backdrop, let us see the election petition which was furnished to us. Lordship will kindly take, but one of their submission is that we have tampered. Very serious allegation has been raised against us, and they want forensic test
Of
of the petition, which was because a copy was given to us, a true copy. 4 pages were missing.
tampering in the copy.
Let me.
No. The allegation is tampering with the copy or tampering
Yes,
with the election.
tampering of the copy,
Not election.
not election.
Oh, here.
Here. So that is their main prayer, that they want forensic science laboratories to be involved in the election proceeding. We fully agree, Lordship. Without going into anything, I bow down and I agree to that prayer. 4 pages were missing. That is a minor mistake. Affidavit verifications not in terms of the procedure laid down by the CPC as well as by the election laws. This is a faulted and flawed election petition. So to support my submission, Lordship,
Please substantiate.
yes. The election petition starts at the 3rd page.
We are looking into the EP now, which was presented.
Which was
No. You are
which was
referring
given to us. I'm going to it, but that is a part of the annexure
of
in
your
our IA.
of your IA.
IA.
Okay, which page?
I just messed up one thing because I have the notice which was given to us the true copy. I was not marking because it may go to the forensic. So I did not put a single dot also, except on the flag marks. And we had to open the pin because we have to give photocopies in the IA. Therefore, this pin was open. So Lordship will kindly come to the election petition page number 1. So Lordship will kindly come to page 81.
Of your IA. Of your IA.
Yes, and IA from the verification of page 82 corresponding. Page 84.
81 is paragraph 19C, 19D, all those.
Yes, Lordship. In that IA, it will be 112. In
112.
112.
Prayer starts at 110.
11, 16, 11, 16, 21. 4 pages from page 1 to page 79. Page 11, page 11, 16, 21, and 22 are
11, 16,
16
21,
and 22
missing.
missing. In paragraph 5 of our IA, we have very categorically stated, Lordship may take that also, that it is stated that upon perusal of the copy of election petition that has been served upon the respondent applicant herein.
Just a minute, please. Paragraph 5
Paragraph 5
of your petition.
of
Oh,
IA.
okay. That it is stated.
That is that upon perusal of the copy of the election petition that has been served upon the respondent applicant herein, it is found that the said copy of the election petition do not contain 4 number of pages, being page 11, 16, 21, and 22. And accordingly, it is stated that 4 pages, being page number so and so, has not been served upon the applicant. Now, that 4 pages are missing. That is my first submission on the fact. Now coming to page 80. 80, the relevant page will be in 112.
Page 80.
8.
No, 112 or 80.
112.
It starts at part of the prayer.
No, a verification of election petition.
Okay, 112, verification, right.
Yes. The copy which has been given to us, the same photocopy is in the eye. So there is no signature of Hafiz Rashid Ahmed Chaudhary election petition. A very serious flaw, Lord. I think Lordship court's copy may have the signature, but our copy is not having.
Served copy does not have, that
does
is
not
your
have. The
submission.
two copies served to us does not have. So this is the original which has been given, Lordship, with the everything in.
But on the right side, on the
That
right.
is attested to be true copy of the petition, election petition. That is number one. There are two requirements. One is that as a deponent, as a verification person, Lordship, he have to verify by putting his signature.
Let us again read it.
We'll go to that, Lordship. Let me first.
Okay, you formulate, then we'll go
Yes.
again. 83 again we'll read.
Page 80. So HRA Chaudhary's signature is not there. Number one, attested to be true copy of the petition, his signature with election petitioner is there on the right hand corner, but there is no verification. So there is no signature here. Now coming to the affidavit part, page 81.
I think page 113.
Yes, 113. It starts from 113, then Lordship will kindly go to page 114.
Next page.
Here, the deponent's signature is there. Attested to be true copy of the petition is there.
Okay.
It has to be notarized. There is no notary. If Lordship's official copy is there, I do not know. But the copy which has been given to me, there is no notarization of this affidavit, which is a mandatory clause, condition. So there is no notarization of this. Now coming to the next affidavit, form 25, page 100, and it will be, internal page will be 83.
115.
It will be 115. So here also, next 116, the deponent's signature is there, attestation is there.
Why is this affidavit, this is under form 25?
Under form 25.
What do you want to show here?
Here, there is again no notarization.
116.
116. No notarization. Thereafter, the document part started from page 85, which will be 117, up to the last page, 185.
Yes.
There, Lordship will kindly come to page 87, 87 internal page.
Yes, 119.
119. So in this, the election petitioner's signature is there, certified to be true copy is there, attestation is missing, and verification and notarization is missing. Basic attestation is missing, Lordship, not notary. Notary is not required, Lordship. Attestation is not there. Only said certified to be true copy. Yes.
Now, what would be the difference between substantially?
Yes,
of
Lordship. If
attesting
we go to
and
the judgment, there is a huge difference.
certifying and attesting?
Absolutely, Lord. That is the core issue, and so many petitions were dismissed on this ground from 1980 onwards. On this ground only, and a direct case of this honorable court in 2000 by Justice Patnaik on the same ground dismissed. I'll please. So that even when I was reading all this from my colleague, I was not very sure. But when I read the judgments, The law is so stringent without any lenience. The law has been followed all across the time.
No, the law is always that sanctity has to be given to the election process.
Yes,
Election petition are not to be entertained as a routine manner. That is the law. But if he,
this
if he,
law, this
if he
procedural flaw.
surpasses the barrier, then a case may be for examination. But you are trying to make out a case that that has not been complied with,
The foundation is not done.
not there.
The
Okay.
foundation has to be there. Why 86 is there, Lordship? It
Okay.
has to be presented as per 81. So the verification here, no attestation. On top of that, if Lordship goes to page from any page from 1 to 85, Lordship will see. So let us take any page before that. Of the
Just a minute. Page?
any page of the election petition, main pleadings.
Okay.
Lordship will see on the right hand top, attested to be the true copy of the petition.
Which page?
Any page from 1 to 85, up to the affidavit.
Okay.
Up to 116, any page up to 116 of the petition.
Oh, yes, attested to it.
Attested to be the,
True copy.
yes. Now coming to the annexers part,
Yes, that is not there.
that is certified to be true copy.
Yes.
According to the election petition, the main pleaded part, as well as all the annexers comprises and composite the election petition. So in every pages, it has to be attestation. 81 Lordship would kindly see. Every election petition shall be accompanied by as many copies thereof as there are respondents mentioned in the petition, and every such copy shall be attested by the petitioner under his own signature to be true copy of the petition. So whether now the issue will come definitely that annexers may not be a part of the election petition, but that also judgment will clarify, Lordship. That every pages of the election petition must be attested by the petitioner under his own signature to be true copy. Now coming to page. So total 23 number of verification affidavits were signed. (119), Lordship will see. Here.
Just a minute. One one nine.
119.
Just before the prayer. Just before the prayer.
No, this is a verification of document number 1. In the IA,
I think
internal page 87.
119. Okay. 11. Yes, verification of document number 1.
Yes.
Yes.
So here also, the down below, certified to be true copy, not attested copy.
Yes.
So that attestation is missing here. So far as verification part is concerned, Lordship, in my humble submission, maybe notarization is not required. For affidavit, notarization is required. In the instant case, notarization in the affidavits are missing. Signature in the main verification of the election petition is missing. All the verifications, there are 23 number of verifications from this page 87 to page 185. Page numbers I'll place from the pleadings. Lordship may mark also this 87, then next page will be 93.
Just a minute. 93. Let us. can you please refer to the
93 corresponding
93 would be 128. Is it 128? No,
125.
125.
125.
Okay. 125, same thing.
Yes. Identically, there are 23 numbers of similar verifications. Everywhere it is certified to be true copy, not attestation of the true copy of the petition. That is not there.
119, 120, 125.
Then
Then,
107 will corresponding 139.
just a minute, 113. 139. 139, yes.
Then internal page 107, that will be just 1 second, 144,
144.
143,
143.
3, one 53, 157, 160,
153, 157, 160,
163, 166, 169, 172,
yes.
174, 176,
186.
Maybe it's for two.
Yes, yes. No, 183, I think.
183 is also there.
183,
184,
186,
186,
186,
189,
yes.
then 198, 17,
198, yes.
205, 208, 7, 210, 213, 214,
214. 214 is not verification.
it is schedule.
Hmm.
That schedule among them. Oh, schedule. 180, yes. Document 22. This schedule is very important. It is also not attested. Then next page also 215. That is verification document number 22. 217.
No,
And
no,
Lord, you will kindly come to the last page.
Mr. Saikia, you have missed something in 215, I think.
215.
Mr. Dutta?
215, document number 22, verification.
Yes, see? Nothing is there.
In our petition.
Not, there is no certification also.
Oh, yes, there is no certification. In this case, no certification. We have missed that. Highly obliged from him. It is 30. And the last page, Lordship, it is 180, 185, the corresponding page with
217.
217. So there that true copy stamp is also not there. So my humble submission that all these are integral part of the election petition which are missing. Now, in the IA, what we have, the relevant paragraph will be paragraph 5 onwards. 5 I have already placed. Then 5, the first part I have placed. Then second part. From the perusal of the served copy of the petition, I have brought it.
Yes. Paragraph 5,
Paragraph 5, the second subpara,
page 6.
page 4. The long paragraph. So all the missing things we have pleaded.
Yes.
Because the first paragraph I have already read out, paragraph 5, the second subpara. From perusal of the served copy of the petition, it appears that up to page 84 of the said served copy of the election petition has been signed by the election petitioner with a blue color rubber stamp attached to be true copy of the petition, and therefore thereafter from page 85 to 185 of the said served copy of the election has been signed by the election petitioner with a blue color rubber stamp certified to be true copy except one page, which this Honorable Court just pointed out. In the served copy of the election petition, 24 number of verifications found annexed by the election petitioner at page so-and-so. The verification at page 80 is in respect of the election petition, and verification at page 87, etc. are regarding various documents. Next page. Moreover, 2 number of affidavits have also been found annexed to the election petitioner at page 81 and 82 and at page 83 of the election petition. The affidavit at page 81 and 82 is in respect of the statements made in the election petition, and the affidavit at page 83 is in respect of the allegations of corrupt practice. Is the additional requirement for when corrupt practice is alleged, then additional affidavit is also to be given, and particulars thereof in prescribed form 25 under Rule 94A of the rule. However, it is seen that none of the 24 number of verifications and 2 numbers of affidavit annexed with the served copy to election petition has any signature or stamp of notary or any authority empowered to that effect.
What you have just argued, this is what is the relevant pleadings.
These are all.
What we have just pointed out to the court is this is the relevant pleadings.
Yes, Lord.
In paragraph 5.
Yes, Lord. Because we have to allege specific. Except one page, we have done everything. So that missing one page, Lord, that is also without either certified to be true copy or attested copy. Both are missing also. That also is fatal. Now rules, regulations are there. Now paragraph 8.
8.
That it is stated that Rule 94A of the Conduct of Election Rules 1961 provides that the affidavit containing allegation of corrupt practice shall be in the prescribed form, Form 25, which enjoins.
Just a minute. This is which act?
Rule 94A of the Conduct of Election Rules 1961. That Lordship will find.
Yes.
If Lordship is having the same copy
Yes.
at page 267.
94A.
94A.
247 it will be. It's a different book probably.
It is inserted.
247.
It was inserted on 27 February 1962, 94A.
A form of affidavit.
Form of affidavit to be filed with election petition.
6.
The rule says the affidavit referred to in the proviso to subsection 1 of section 83 shall be sworn before the magistrate of the first class or notary or commissioner or court and shall be in Form 25. So 3 authorities are prescribed here. And in our cases, none of the authorities seal and signature are present in either of the three affidavits. So I'm going back to paragraph 8 now.
Just a minute, 94A, form of affidavit. Yes,
So I'm going back to paragraph 8.
yes, please.
That it is stated that Rule 94A of the Conduct of Election Rules 1961 provides that the affidavit containing allegations of corrupt practices shall be in the prescribed form, Form 25, which enjoins accompaniment of solemn affidavit to be sworn by the election petitioner, duly verifying correctness of the alleged corrupt practice mentioned in various paragraphs of the election petition, and attestation by the district magistrate or notary or commissioner of oath. However, as stated above, in the copy of the election petition supplied to the respondent applicant herein, certifying to be the true copy, do not contain such verification by a district magistrate or notary or commissioner of oath, as is reflected in page 81, 82, and 83 of the served copy. Three affidavits I have placed on.
Yes,
This being a mandatory requirement, the instant petition is liable to be dismissed for non-compliance of this provision, as the affidavit annexed with the served copy of the election petition is without any signature or stamp of a magistrate of the first class or notary or commissioner of oath. Though most pertinently and most surprisingly, upon verification by the advocate of the applicant herein, it is seen that the original affidavit filed by the petitioner has been attested by the commissioner of affidavits. Thus, in view of the above stated fact, the question arises for consideration is whether the copy of the election petition accompanied by supporting affidavit served on the respondent applicant herein, along with Form 25 prescribed under Rule 94A of the Conduct of Election Rules 1961, without being duly verified by the district magistrate or notary or oath commissioner, though contained in the original affidavit, can be said to be true and correct copy of the election petition as envisaged in section 81(3) of the Act. This question has been directly raised. Lordship, I will place this judgment straightway, Lordship, not from these pleadings. Next page, leaving this judgment now. Next page, page 11. It is humbly submitted that the issue has been settled by the Honorable Court in Katana of Judgment. The judgment I am again placing, will be placing. And I am praying for dismissal of the election petition. So these are the basic pleadings, Lordship. The submission and the pleadings relating to the law and the various judgments, Lordship, that are not very important. But the factual part, it is there. So straightway, Lordship, the judgment which covers our case is a coordinate bench judgment of this Honorable Court 2000. Then I will place the Supreme Court judgment. So in that judgment also, the most important Supreme Court judgments were relied upon and quoted also. Anita? 2001, 1 Guwahati DLR, page 404. Other cases, I will refer to relevant paragraph. In this case, Lordship, the whole judgment is very important because it squarely covers the factual situation in the instant case. May I read, Lord? Have Lord got it. The petitioner in election.
Fung Jathang.
Yes, Punjathang versus the next Lordship will.
Angkhan Lian.
I will not try that.
Angkhan Lian, this is not very difficult. No, you see, it's not very difficult. At times, Angkhan Lian is very.
Angkhan Lian, yes, Angkhan Lian. Angkhan Lian.
It is
But when we see NGKHH, then we get little bit scared. Anyway, Lordship, Punjathang versus Angkhan Lian. Citation 2001, 1 DLR, page 404. Justice Patnaik. The petitioner in election petitioner number 1 of 2000 was a candidate from 48 Churachandpur Assembly in the 7th Manipur LA election. In the said election, respondent number 1 was declared elected by the state constituency on 26 to 2000. Respondent number 2 and 3 were also candidates for the state constituency in the election. Respondent number 5 is the Chief Electoral Officer, State of Manipur. Respondent number 6 was the returning officer of the Churachandpur Assembly constituency. 7 to 10 were the presiding officers, etc. In the election petition, the case of the petitioner is that respondent number 1 and his agents man committed various corrupt practices. Here also the same allegation within the meaning of section 123 of the Representation of People's Act 1951 as narrated in the election petition, and the election to the respondent number 1 was liable to be declared void under section 100 of the RPA 1951. The petitioner has inter alia prayed that the election of the respondent number 1 be declared void and the petitioner be declared elected from the state assembly constituency. On 27th April 2000, the court admitted the election petition and issued notice to the respondent. The respondent number 1, returned candidate, has appeared and filed civil miss case number 3/2000. In the said miss case, it is stated in paragraph 5 that copies of the affidavit supplied to the respondent in support of the corrupt practices mentioned in the election did not contain due verification and attestation of the oath commissioner or the prescribed authority, and such omission in the copies of the affidavit supplied to the respondents as true copies was not a curable irregularity, and the election petition was liable to be dismissed on this ground alone. Respondent number 1 has also filed in the court the summons and copies of the election petition received by him along with the summons to show that the copy of the affidavit along with the copy of the election petition does not contain verification or affirmation by the oath commissioner by the prescribed authority. Similarly, respondent number 5 and 6 have filed a preliminary objection to the maintainability of the election petition, stating in paragraph 1 thereof that the copies of the affidavit of the petitioner dated 9/3/2000 in Form 25 prescribed by Section 83 of the RPA 1951, accompanying the copies of the election petition furnished to the respondent number 5 and 6, do not contain the affirmation of the court commissioner. Along with the said preliminary objection, summons from the court and the copies of the election petition and the accompanying affidavit have also been filed to show that in the copies of the affidavit accompanying the copies of the petitioner as served on the said respondent 5 and 6, affirmation of the oath commissioner or the prescribed authority has been omitted. The court therefore took up hearing of the aforesaid preliminary objection raised by the respondent number 1 and 2. At such hearing of the preliminary objections, Mr. T. Nandakumar Singh, learned counsel appearing for the respondent number 1, submitted that subsection C of 81, section 81 of the RPA 1951, provided that every election petition shall be accompanied by as many copies thereof as there are respondents mentioned in the petition, and every such copy shall be attested by the petitioner under his own signature to be true copies of the petition. He contended that the said subsection 3 of section 81 required that a true copy of the election petition and a true copy of the affidavit have to be filed along with the election petition for each of the respondents. He further submitted that subsection 1 of section 86 of the RPA 1951 provides that the High Court shall dismiss an election petition which does not comply with the provisions of section 81 of RPA 1951. According to so and so, therefore, where a copy of the election petition and a copy of the affidavit filed along with the election petition under subsection 3 of section 81 of the RPA 1951 contain omission of vital parts which exist in the original petition, there is no compliance of the provisions of subsection 3 of section 81, and the High Court is under mandate under subsection 1 of section 86 of RPA 1951 to dismiss the election petition at the threshold. Sri Nandakumar argued that since the copy of the affidavit accompanying the copy of the election petition served up along with the summons the respondent number 1 does not contain verification or affirmation of the oath commissioner or the prescribed authority as indicated in Form 25 under the 94A of the Conduct of Election Rules 1961, the election petition is liable to be dismissed for non-compliance of the provisions of subsection 3 of section 81 of RPA 1951. In support of his submission, he cited the decision of the Supreme Court in Sipra versus Santilal Coil AIR 1996 Supreme Court so and so, in which the Supreme Court held that true copy of the election petition supplied to the returned candidate should be a sine qua non, contain the due verification and attestation of the prescribed authority and certified to be true copy by the election petitioner in his own signature, and if such verification or attestation by the prescribed authority is omitted in the copy of the election petition furnished to the returned candidate, it cannot be said that a true copy of the election petition has been furnished to the returned candidate and the statutory requirement of subsection 3 of section 81 is not complied with and the election petition is liable to be.
Can you in the meantime ask any of your colleague to have a look at
The judgment.
if you have got it to 2024, it's a neutral citation 0 INSC. 2024 0 INSC 689. This is also gone from, I think, Nagaland. Hawakip. Hawakip will be Nagaland, I think. Hawakip.
Wakip will be Nagal.
Nagaland. Madam, can you take out this 2024 0 INSC 689? Because this is one of latest judgments. I just had a cursory view
Lord.
on substantial compliance because this judgment is based on many Supreme Court judgments. We want to
Absolutely.
see what are the strength of the judges, whether these
Law is
judgments
still
were
valid or there is-
considered or not in the
Yes.
subsequent one. At times it is ignored. At times it's considered and something else is said. In that context. Name of the party, yes, Kimneo, KIMNEO, Hawakip, HAOKIP. KIMNEO, Kimneo, Hawakip, HAOKIP. Supreme Court, obviously. I think Justice Dhulia's judgment.
Yes. 14 lines from below.
Yes.
Mr. Nanda Kumar Singh further submitted that in PM Jacob versus so-and-so, reported in 1998 SC, a slightly different question arose as to whether the name, designation of the notary and the seal and stamp of the notary also were required in the copy of the affidavit, accompanied the copy of the election petition furnished to the respondent, and as to whether the absence of such name, designation, seal and stamp of the notary in the said copy of affidavit as furnished to the respondent, there was non-compliance of the provisions of subsection 3 of 81, and the Supreme Court was not too sure as to whether the principle indicated in the case of Dr. Sipra would apply to the facts in the case of PM Jacob, and took a view that the matter required consideration by a larger bench. Thereafter, the Constitution Bench held in its decision that PM Jacob versus so-and-so, that the defect found in the true copy of the affidavit in Dr. Sipra's case was not merely the absence of the name of the notary or his seal or stamp, but a complete absence of the notarial endorsement of the verification as well as absence of affirmation or oath by the election petitioner. Sri Nanda Kumar Singh explained that the Constitution Bench in PM Jacob versus so-and-so has not in any way overruled the altered law as laid down in Sipra. He therefore vehemently argued that the election petition should be dismissed so-and-so. Then I am skipping paragraph 4, paragraph 5. These are submissions of the other respondents.
Okay.
Coming to paragraph 6, the quotation of the law, which I have placed at the very beginning, Lordship.
Yes.
81.3, 81.1.
Yes.
Then 86.
Okay.
These three provisions which I have already placed.
Yes.
Now, the findings of the court.
Hmm.
A reading of section 81(3) quoted above would show that every election petition shall be accompanied by as many copies thereof as there are respondents mentioned in the petition, and such copies shall be attested by the petitioner under his own signature to be true copy of the petition. In M. Kalalam versus M.S. A.S. Muhammad, year 1978, the Supreme Court held that an election petition for the purpose of said subsection 3 of section 81 is confined not only to the election petition proper, but also includes a schedule and annexures contemplated in subsection 2 of section 83 and the supporting affidavits referred to in the proviso to section 83(1). So, pausing here for a moment, Lordship, I have also said that at the very beginning that annexure also includes and makes a part of the
petition.
election petition. Thus, the affidavit accompanying the election petition in the prescribed form in support of the allegations of corrupt practice and particulars thereof referred to in the proviso to section 83(1) is also part of the election petition for the purpose of subsection 3 of section 81. Therefore, where the copy of the affidavit accompanying the election petition furnished for the respondents is not a true copy of the affidavit accompanying the original petition filed in the court. So, in the court's copy, everything is there. There is no compliance with the subsection 3 of section 81 of RPA 1951. The contention of Mr. Novakumar Singh, learned counsel for the election petitioner, that affidavit is not part of the election petition for the purpose of subsection 3 of section 81 is not correct. Paragraph 7. Section 86(1) of RPA 1951 quoted above provides that the High Court shall dismiss an election petition which does not comply with the provisions of section 81 of the RPA 1951. Accordingly, where the copy of the affidavit accompanying the election petition furnished for the respondents is not a true copy of the affidavit accompanying the original petition filed in the court, the High Court is under a mandate under section 86(1) to dismiss the election petition. In the present case, at the bottom of the affidavit accompanying the original petition filed in court, the Commissioner of Affidavit, Guwahati High Court, Imsolvents, Manipur on 90/20K 2000 has recorded the affirmation made before him by the declarant and has stated that the declarant is identified by Somorjit Advocate and has certified that he has read over and explained the contents to the declarant and the declarant seems perfectly to understand the same. These affirmation and certificate have not been copied out in the copies of the affidavit accompanying the copies of the election petition furnished to the respondent number 1, 5, and 6, and this fact has not been disputed by the election petitioner. Here, they have disputed because they won forensic examination. That is the only distinguishing factor with this case. There, it was an admitted fact that, yes, we have failed to put the signature or the verification. In the instructions, if you look at their reply or response, they are doubting us. They won examination to the forensic science laboratory. So that is the only distinguishing fact here. So far as this judgment is concerned. May I proceed now? Thus, the copies of the affidavit accompanying the copies of the election petition filed along with the original election petition and the affidavit for the purpose of the said respondent number 1, 5, and 6 do not contain the affirmation and the certificate of the Commissioner of Affidavit. The question as to whether absence of such affirmation or verification by the Oath Commissioner in the copies of the affidavit accompanying the copies of election petition furnished to the respondent amount to non-compliance of the provision of section 81(3) of the RPA arose for the decision in the case of Dr. Sipra versus Santilal Goyal, and the Supreme Court held that it amounted to such non-compliance with the provisions of section 81(3), and the election petition was liable to be dismissed for such non-compliance under section 86(1) of the RPA 1951. Paragraph 11 of the judgment of Dr. Sipra, AIR 1996, Supreme Court 1689 is quoted herein below. In Purushottam versus Returning Officer Amravati, AIR 1992, Bombay, the present question had arisen. In that case, a copy contained omission of vital nature, that is attestation by the prescribed authority. The High Court had held that the concept of substantial compliance cannot be extended to overlook serious or vital mistakes which set the character of a true copy, so that the copy furnished to the returned candidate cannot be said to be true copy. We approve of the said view. The Bombay High Court view was approved by the Honorable Supreme Court. Verification by a notary or any other prescribed authority is a vital act which assures that the election petitioner had affirmed before the notary, etc., that the statements containing imputation or corrupt practices was duly and solemnly verified to be corrupt statement to the best of his knowledge or information as specified in the election petition and the affidavit filed in support thereof. That reinforces the assertion. Thus, the affirmation before the prescribed authority in the affirmation and the supply of its true copy should also contain such affirmation so that the returned candidates would not be misled in his understanding the imputation of corrupt practices was solemnly affirmed and or duly verified before the prescribed authority. For that purpose, Form 25 mandates verification before the prescribed authority. The object appears to be that the returned candidate is not misled that it was not duly verified. The concept of substantial compliance of filing the original with the election petition and the omission thereof in the copy supplied to the returned candidate as true copy cannot be said to be curable irregularity. Allegation of corrupt practices are very serious imputations which, if proved, would entail civil consequences of declaring that he becomes disqualified for election to a maximum of 6 years under Section 8A, apart from convention that Section 136(2). Therefore, compliance of the statutory requirement is an integral part of the election petition, and true copies supplied to the returned candidate should be sine qua non, contain the due verification and certified to be true copy by the election petition in his own signature. The principle of substantial compliance cannot be accepted in the fact situation. The aforesaid decision of the Supreme Court in Dr. Sipra was followed by the Supreme Court in Haricharan Lal Joshi, 1996, paragraph 2. It is not necessary for us to go into the grounds on which the election petition was dismissed by the High Court. Suffice it to state that objections raised by the respondent regarding non-supply of the true copy of the affidavit is a formidable objection which merits acceptance in view of the recent judgment of this court in Dr. Sipra versus so-and-so. Therein, a copy of the affidavit supplied to the respondent was not attested by the Court Commissioner. This court, after considering the entire case law, held that the affirmation before the prescribed authorities in the affidavit and the supply of its true copy is mandatory, so that the returned candidate would not be misled in his understanding that imputation of the corrupt practices were solemnly affirmed and duly verified before the prescribed authority. For that purpose, Form 25 prescribed by the Section 83 requires verification before the prescribed authority. The concept of substantial compliance has no application in such a case. It is seen that the copy of the affidavit supplied to the respondent does not contain the affirmation by the Court Commissioner. Under these circumstances, the defect is not a curable defect. Therefore, the dismissal of the election petition on this ground is sustainable in law. The aforesaid two decisions of the Supreme Court made it abundantly clear that where the copies of the affidavit accompanying the copies of the election petition furnished to the respondents did not contain the copy of the affirmation or verification by Court Commissioner or prescribed authority, the election petition was liable to be dismissed for non-compliance of the provisions of Section 81(3) of the RPA 1951. Then paragraph last, the election petition was dismissed. So that judgment is already quoted, Lord Dr. Sipra. And it is a three-judges bench. So if necessary, the law is well settled so far as our facts are concerned. I do not want to burden this honorable court with additional identical judgment. If something is required in my reply, I will definitely, Lordship will kindly keep me that.
You are mainly on the part of non-compliance of the requirement under the Act.
Under the Act,
Uh,
81,
81,
81 3.
81(3).
3.
And you have shown that in the copies furnished to you, apart from the objection that 4 number of pages 11, 16, 21, 22 are missing.
Yes.
So far as the requirement of verification is concerned,
Yes.
both in the pleadings as well as in the documents and schedule, that is not meeting the requirement of.
Yes, that
the
is
law.
attestation of the all pages of the petition,
Yes.
including the
And
annexer. That is
here-
number 1.
Here in the case of, what is that case?
CIPRA.
Not CIPRA, the other one.
In the CIPRA's case, affidavit, the attestation verification was not there. Here
No,
also,
M. Kamalam. M. Kamalam, you said the election petition also includes schedule and annexures,
Lordship,
not only the pleadings.
not only the
Entire thing would be.
entire thing.
And so what is required for the pleadings would also be required for the,
Absolutely, Lordship.
that is your submission.
That is my submission. This is one submission. The other submission is that so far as affidavits are concerned, I'll place once more the
Okay, we'll come back at 2 o'clock.
Lordship.
We were so engrossed, we did not even notice. New subject, what a quote.
Same here, Lordship. And after reading all this, Lordship, I thought that
This
I have
subject
to
is
get
always
away
a new
from-
for me too. This subject is always a new for me too.
it's better to get away from election petition. Regarding the attestation and verification. And apart from that, I am also harping on another ground, Lordship. So my one submission is that all the pages, including the pages which were annexed with the plain Lordship, also form the election petition, and in every page there has to be attestation. Whereas in all the annexers, they have annexed, there is no attestation. Certified to be true copy, that was the only endorsed. That apart, Lordship, in the affidavit, sorry, in the verification at page
112.
112,
Yes.
112, there is no signature of the person who has verified. Only what is there? Attested to be the true copy of the petition. That is a different part, and verification, endorsement, and his affirmation. There is no signature. And in the affidavit, Lordship, page 112, 114, there is no notarization. That is the general affidavit. And Form 25 affidavit,
116.
116, same, no notarization. That apart, Lordship, if this Lordship may hear the other side on this point.
No, there's one point which we had raised. You said that you'd clarify that whether certification and attestation are the same thing or different things.
Certification and attestation.
Yes. You said there's a vast difference.
This is totally different.
Yes, and you said that you'd submit on that, some case laws on that.
Oh, no, I have. Maybe I was not correct in making my submission. But there
Because
is
we had seen that though the requirement is attestation,
attestation.
but we find that certified to be true is there. Whether that will meet the part of attestation on that.
Yes, now if Lordship is pleased to look at their certification, what
Yes.
is that?
Page,
Any page, the later part, annexed,
okay. Certified to be true copy.
true copy. And whereas attestation is, Lordship will say any of the main part, attested to be the true copy of the petition. So attestation is required in respect of all the pages so that it is a part of the petition, not in respect of a particular page. So far as this certified to be true copy, election petitioner is saying that certification to be true copy. It has nothing mentioned about the petition. But I'll, if I get the opportunity on another day, Lordship, regarding in my reply, then I will definitely.
Have you
try
looked into that matter, Hawkib? Hawkib, what is it?
Yes. Something I. Copy that.
That is order F211. Photo. Yes, order 7, rule 11 application,
Yes.
non-disclosure of the cause of action.
Oh. Come to paragraph 6, 83 has been quoted.
83 is quoted.
Hmm.
Paragraph 4, before the High Court, the present appellant has moved an application under order 7, rule 11 for rejection of the plain on the ground that it does not disclose any cause of action, as it does not specify any corrupt practices alleged to have been committed by the appellant, nor is there any averment regarding concealment of her income asset. Therefore, the election petition does not comply with the requirement of Section 83 of the RPA and ought to be dismissed at the threshold. The High Court, by the impugn order, held that whether the appellant had any income or not and whether he had given wrong declaration at the time of his nomination need to be looked into in trial, for which evidence has to be laid by the parties and examined by the court. The petition cannot be dismissed under order 7, rule 11 application. Consequently, the application under order 7, rule 11 filed by the appellant was dismissed. Aggrieved by the appellant. Aggrieved the appellant is now before us. Next, paragraph 7. Over the years, election petitions have been filed invariably on the ground which are similar to the ones raised before this court. The only question is whether the court can dismiss such a petition at the very threshold on an application under order 8, rule 11 CPC, or the petition needs to be detailed consideration by the court. The answer to this will depend upon what kind of statutory compliances have been made in the election petition. The case of the present appellant before this court is that if the provisions as referred above, wherein material details have to be given by the respondents and particularly the details of corrupt practices, etc., has to be strictly construed, and any deviation by the respondent on this requirement shall make the petition liable to be dismissed at the very threshold. All the same, this is not what the requirement of law. Rather, the settled position of law here is that an election petition should not be rejected at the very threshold where there are substantial compliance of the provisions. Thus, we will have to see whether substantial compliance of section 83(1)(a) and 83(1)(b) has been done by the respondent. What is 83(1)(a)? 81.
83(1)(a).
83(1)(a). That there shall be a concise statement of the material facts on which the petition relies. B, whether shall state forth full particulars of the corrupt practices. We are not on A and B, we are on C.
Now kindly come to the observation in paragraph 11. They have quoted another Supreme Court case.
Yes.
Paragraph 11. They have quoted Siddheswar.
In a more recent case, also from Manipur, this court upheld the dismissal of the returning commission, dismissal of the returning candidates order 11 rule, order 7 rule 11 application by the Manipur High Court in an election petition. The court, after referring to and applying the test laid down in Siddheswar Supra's case, has held that the position of law that emerges from the above referred cases is clear. The requirement to file an affidavit under the proviso to section 83(1)(c) is not mandatory. It is sufficient if there is substantial compliance, as the defect is curable and opportunity may be granted to file the necessary affidavit. In view of the reasons stated above, we see no reasons to interfere with the finding of the High Court of Manipur, and the election petition discloses a cause of action and there is substantial compliance of the requirement provided under provisions of RPA, and thus the petition cannot be dismissed under order
7 Rule 11.
7. Now the issue is very clear. Here, in the main petition, if it was not done, that is what indicates here. The main petition, if they have failed to give the affidavit. That situation is different here. One hand, they have given the original copy by fully complying with everything. The true copy given to us, on the basis of which we have to fight the case out, including filing of the WS. On top of that, Lordship, this judgment, let me examine, because this judgment which is quoted here, let me examine also that.
No, that is the context. We asked you what is the
Yes.
strength of
Yes.
this judgment and the judgment of.
Because the issue there is totally different actually. Here, ours is, Lordship, it's a true copy, issue of true copy, whether true copy should be as verbatim as it is before the Honorable Court as well as to the respondent.
No, Mr. Saikia, see, one is on the aspect of the copy served upon the returning officer, returning candidate.
Returning candidate.
And the other is, which 83(1)(c) says, is the requirement to file an affidavit supporting the averments. In the case which has been referred,
Yes.
Siddheswar, which paragraph 14 has been quoted, it has said, gone to the extent that even 83(1)(c) is not mandatory, which normally one would think that it would be an essential part. How can you file an election petition without an affidavit verifying the pleadings? Even that has held to be not mandatory. In that context, whether the
That
copies
is why
are,
let me examine this.
and why it will be necessary, because the citations which you have relied upon, those in categorical terms have said that in the copy, if you have not abided by a section, it will go. Justice Patnaik's judgment, apart from being a judge of a concurrent bench, but it has referred to all the Supreme Court judgments. In all those cases, non-compliance has been held to be fatal.
And Supreme Court has also said that this kind of lacuna is not curable also.
Not curable.
Not
Correct.
curable also.
That's the language.
Yes.
And if you suppose, if you see this judgment,
Therefore, this judgment, in my humble submission, prima facie, it is per inquiry, number one. Number two, this judgment is given by two judges. All the judgments which were relied by my Lord Justice Patnaik were three judges bench. And what exactly is the core issue here? What exactly is the issue, Lordship? We'll have to verify whether those facts are applicable in our case or not. Because here it is a case, because we have taken that ground also, that the allegations regarding corrupt practices, that also have to substantiate by giving full particulars. That particulars are missing, number one. And that has also to be supported by a.
no, we have not gone to the particulars.
No,
the facts.
that is a ground in my, because I have not argued, because this is the ground which
Let
I
us
am
touch on the
arguing.
merits, but you are touching on the grounds of procedural defects.
Procedure, because as ground is also available.
No, the aspect of substantial compliance which has been tried to be raised here. What is substantial compliance? Will it take care of a defect which?
So far as non-attestation, number one, and non-notarization, these flaws are not curable. Specifically, Bombay High Court said the same thing, upheld by the Supreme Court also, and repeatedly, not only once. And that law is still untouched. And the judgment which just now I have read, which Lord has given us the indication, all these judgments were never discussed here. The law which is well settled, just mechanically, this is a curable mistake, that will not be sufficient. All the judgments will be, Lordship will have to examine and adjudicate.
What is this, the other one? GM Siddheswar and the other one?
Thomas.
Thanjam Arun Kumar?
Yes, in that my Lord Justice Patnaik judgment, that both the judgments are quoted.
No, two judgments, page 10 and paragraph 10 and 11 of Hawkeep. There are two further judgments of Honorable Supreme Court, 2013 and 2023.
2013 and
2023. Please examine this also.
Yes, Lordship, what I would like to request now, Lordship, that let me examine all this and make a further submission on this.
No, otherwise we have We have got your point which you are trying to argue.
Yes,
I
Lordship.
will like to hear Mr. Pathak.
Yes,
And in the
Lordship, but I
meantime-
would like to argue because what are the factual background of this judgment? So Lordship, maybe please to hear the other side. Then
Yes, yes.
in my reply also, I may add a new thing also. That opportunity may be given. to me.
No, no, obviously,
Yes,
we
Lord-
want to
No,
have,
only that.
we want to do whatever is possible from our side to
Lordship,
lay down the things in the
Correct,
proper
Lord.
perspective.
Lord.
Without being.
Lord.
Okay. Yes, Mr. Pathak. It has gone to a new dimension.
There are few dimensions
Mr.
more.
Saikya is successful in taking
There are
the
few
code to
more
a new
dimensions,
dimension.
dimensions left.
Huh?
There are few more
Few
dimensions.
more dimensions left.
Left. My lord, before I come to the allegation that has
Yes.
been raised in the 86 application, I just want to
These
highlight.
are not allegations. He is only showing some defects. He's not alleging anything.
Allegations in the sense of defect.
Defects, yes.
For me, it is not defect. It is, that's why it is an allegation, which I have to now count.
Allegation of defect.
Allegation
The
of defect.
allegation is against us tampering. In the reply, they have used the
That
word
we have
Because
not
why
seen.
tampering also I am coming.
That we have not seen.
That
We
also,
have,
now I have
I
taken,
know.
and why I have taken, I'm,
we have filed an objection.
I have filed an objection to my lord. I will also come to it.
Put objection from court.
I myself will come to it.
No, no. Objection from court.
Objection copy to I send it.
Huh?
We have filed a common objection in 3222 and
Objection I do.
3340.
But objection in 3222, man. Does the common?
It's a common objection filed for both. Not, is ever allegations of defects are similar in both the eyes.
Yes, yes, there is a common objection.
And reason for giving common objections also I have taken.
Just a minute. But we may not endorse a common objection.
The reason is,
One is for extension of time. You are very well, you have the liberty to object. The other is a very serious
the
claim
reason is,
that your petition should be
Your
dismissed at the
document-
threshold.
reason why we have given a common objection is,
Yes,
on the fourth occasion when they asked for extension of time,
right.
this is the first time they raised the same allegations as they have raised now in the section 80. In the fourth application that is pending on board today, that it is a new allegation coming up. Initially, we are ill, we are sick, here for extension. When it was rejected, the fourth time they said, no, this is not sickness.
No, that rejection was not for sickness, not on merits. That rejection was only strictly on the basis
Not
of
on merit,
procedure.
but they have said
On procedure.
on procedure.
Mm.
Now, after that rejection, they have filed a 3222
For extension.
extension on the ground that these are the allegations, we cannot file WA.
Okay, right.
And these allegations in verbatim, I'm coming to this
344.
section 86
Okay.
application. So therefore, in the beginning, my lord, I have raised the allegation raised against us in that application because it cannot go uncontroverted. And allegations raised in this.
What prevented you from filing a separate objection?
Well, I have also paved leave. I'll file a separate
No,
objection.
because this needs to be adjudicated phase. If a 711 is filed in a suit, duty of the court comes to adjudicate 711. If
Then
711 is allowed, nothing
Adjudication of
remains.
others will not be necessary. at all.
Exactly. that is
That's why I have
different.
paved leave of the lordship.
So 344 is of paramount
That stage
importance.
we have not come. Double stage we have not come.
Mm.
My duty is to face the 86 part.
That is it, 3344.
My lord, that's why
3340.
my humble prayer is that it should be taken as part of the as a objection in 33440. In the beginning of your lordship, 3340 it is
We have some reservations still.
my lord,
We still have some reservations.
about
Filing a common objection to two applications having
my
separate
lord,
further.
I may be granted leave to file a separate objection in 344.
The same objection is change in number, file it.
My lord,
Yes,
that's what I am going to
No,
do,
see, election petition, this is not writ petition.
my lord.
That,
I will do it by tomorrow itself, my lord. Only I have to
See, Mr.
segregate.
Pathak, hearing you is not a problem, but we don't want something to be
Mile.
at this threshold, biggest foundation. If we proceed on the wrong presumption, it may not be proper. We have got the case of the respondent, what they want to plead,
My lord,
and you have also heard them. You want to meet those.
my lord, I have to beat
Oh,
that. Otherwise,
those.
my whole election petition goes.
And he may be correct in contending that if these defects are not curable in nature, then there is no scope to go into the election petition itself.
My lord. So better I file a separate objection, segregating both. It will be the same statements repeated again.
Let it be same statement.
Same
But we thought that you had filed it. We in fact
That's how-
indicated to you, Mr. Datta,
What?
but do it.
No, on my instruction they did it. Well, it's not their fault, it's my fault. What happened?
No, we cannot
It's
assign
my-
a fault
I
on a
must-
senior council.
As a senior counsel, I must,
We cannot assign a fault
the
upon.
day I became
We can
senior,
assign a fault upon Mr. Datta.
the
not
day I
upon you.
became senior, anything wrong or in that creeps up in the court proceeding is because of the senior counsel, not for any other counsel. I own the.
No, I just think it on a different
My lord,
perspective. I
I'll
think
file- In
any
three
filing
people-
of two objections would be necessary.
My lord, that I will definitely. Can I proceed with the 3340 in the section 86 application? If I take it as a
No,
section. 86,
that application, that objection which you have filed, if you come to that objection,
My lord,
it is filed mainly in 3222.
objection of the.
It is a 14-page objection with 2 pages of verification and affidavit.
My lord,
Now, if you want to proceed, we can hear you, but we're.
no,
just
my lord,
holding
it
it
will be
up.
my duty. Your lordship is correct and three people to come.
Your objection
Objection
has
for
been
the-
filed on 7th of November.
My lord, I have got it. In the cost title, I have written objections of the election petitioner against IA number 3222
And
and IA number so and so. Then in the paragraph 1, I have said that since the allegations raised in IA number so and so seeking extension of time to file written statement and IA number so and so seeking dismissal of the election petition on the ground that the purported soft copy is not a true copy of the election petition are based on the same set of allegations. The objector craves leave of the honorable court to file the present common objection against both the aforesaid interlocutory applications filed by the return candidate. However, the objector also craves leave. My lord, we will file separately.
I think
I proceed after the filing.
you file it, can you file it tomorrow?
I'll file it.
Or you file it before Wednesday, without if you
No,
are
only
making
problem
an-
that
making a
tomorrow I will
statement.
file as the days are going, my lord.
We can have this
I
on
have
Thursday.
little problem,
Thursday?
my lord. Actually, there are some personal difficulties
No,
for
no,
next year.
subject to convenience of the parties.
No, more.
Let it, yes, Lordship, I cannot object to that. If it is on Thursday, we have no difficulty.
Thursday, you are okay?
I have.
No, tell a date of your choice.
Then in the first week of December, Lord.
No, first week of December, this court will not be here.
When the next.
This court has
Second week of December. Then.
first and second week, we are in outstation. We come back on 15th.
From 28th, up to 28th, I'm not here, Lord. From 22nd.
I come back, this court comes back here on 15th. We have a schedule at Aizawl. 2 weeks.
Well, on
16th.
You're most welcome to come to Aizawl.
My lord, I would have.
Your place, his place.
I would
His
have.
place,
His
Lord.
place.
The original.
Original place.
Originally inhabited.
I would have loved to come, but because of some
You
personal.
can be the host in
My lord,
Aizawl.
my
You can
lord.
be the host in Aizawl. You
I
can
have-
be the host.
My lord, I would have loved to, because in Law Research Institute, when they went there to conduct a seminar, I became the official host for the Law Research Institute.
And my tragedy is that till now I have not visited.
The interesting part is, when someone learns
Info and
Mizo, the
Aizawl I have
difficulty is,
Race all everywhere.
they put the subject first. Suppose I1T, we put the subject later. But they say Timpui Kadu, that means TI1.
TI1.
They put the subject first. The best part of the language is that put the subject first, then tell what they want.
Importance to the subject.
Yes,
Head
important.
note.
Suppose someone says Toyotoyan, that means rice have you eaten?
You want new Mizo also.
Because to work in Mizoram, local, I don't
Very
know
good.
how to write, at least because my junior was from Mizoram.
Very good.
Maybe have some other activities also, we do not know, Lordship. We
In,
have to go.
in the young days,
25
everyone
years.
has their
25
extracurricular
years, we
activities.
have to go back.
When the young days, everyone has their extracurricular activities.
He is still young, Lordship.
My
Why,
lord,
why you are confining into young days?
my lord,
Somebody may be offended.
the best part of my life is gone. The best part of my life is gone. With
There
the-
are few evergreen lawyers here, Lordship, and one of them is
It's no more there. The green has become a gray now. The green is no longer there. It has become all
Gray
gray.
is a fashion now.
My lord,
he is in fact.
Gray is a fashion now.
that I don't know.
Gray is a fashion. Green is outdated.
That is why you have to go to the field again.
Would have loved to, but because of circumstances at home, I dare not to.
So 16th of December, Lordship. If it is not in conflict.
In the meantime, my lord, I may be allowed to file the
But
separate.
you just try to find out before we leave, if you can at least hear this, and since it's fresh in our mind, what Mr. Saikia,
My-
in the meantime, he can also go through
Yes,
the
okay.
other two judgments.
My lord,
Day after tomorrow, is it possible? Day after tomorrow? May not be possible.
because I'll be in
Okay.
fasting and.
Okay. Then tell us a date.
December 16th, just before the Christmas.
Christmas now. Christmas now, correct.
16 December is Monday.
Either you invite
Possible.
or I invite. Let you invite.
We should be here back on 14th, 16th
Sure.
is possible.
Well.
Okay.
And within 2 days' time, I'll separate it and file separate.
Heard Sri D. Saikia, Learned Senior Counsel for the
separate too.
applicant who has filed this petition. এখানে প্রথমটা লিখে দিবা, হ্যাঁ? এটা order is it 4/11/2024.
Remove the record.
Also heard Sri K.P. Pathak, Learned Senior Counsel, assisted by লিখে দিবা এটা, DCK assisted by so and so, and K.P. Pathak assisted by so and so for the opposite party election petitioner. Full stop. Though there has been some length of hearing, comma, Sri Pathak, the Learned Senior Counsel for the opposite party election petitioner, has submitted that though that আগত do আছিল না, বদলাই দিম দে এইটো, that though a consolidated objection has been filed in IA Civil 3222 of 2024, which was primarily for extension of time to file written statement, and the present IA, which has been filed under section 86 of the aforesaid act, comma, he would like to file a separate objection
In both the missing.
in both the miscellaneous case. You can file one and you can say that this is only for this. It's up to you.
I couldn't.
You can forego, since you need not file two now.
Actually, extension application question does not arise.
Now you
now.
you may not file two now. You can
It-
just say. you
It
can
all
file
depends on the outcome of the.
separate application, as within bracket as করে দিবা. Separate objections. Full stop. As agreed to by the learned counsel for the parties, let the next date be fixed on 16/12/2024. Full stop. Since substantial questions have been raised on the maintainability of the election petition, comma, though belatedly, comma, till the adjudication of this petition, comma, the period for counting the limitation prescribed for filing written statement would not be taken into account.
Well,
Highly of that.
may I add here, at least, I think you'll be happy to know about. The word shall appearing in section 8(1) is directory, not mandatory.
8(1) of,
8, order 8, rule 1,
Hmm.
regarding that 30 days, then another 2 months.
yes, is that,
Yes, that is-
Salembar 2,
That is directory.
Salembar
Anytime he
two.
can file with an application that it may be taken on record.
And that is what the problem has been created by the courts.
I
Entire
remember your lordship
amendment,
pointed out in the beginning.
entire amendment has become redundant now.
Absolutely, but for commercial suit, it's not.
It's not there, commercial suit.
It's not a commercial
No,
suit,
no.
but for commercial suit, it is mandatory, it's mandatory.
Even in Arbitration Act, if you file 34
Hmm.
for setting aside, there is 34(5),
34
which
fine.
says that before filing 34, you need to give him a notice
Notice.
and bring that notice in the to the information of the court by way of an affidavit.
Yeah.
And the word uses shall.
Yeah.
Supreme Court has read down.
Yeah.
This shall is not mandatory, but directory because consequence has not been laid down. That is the only.
34, my lord, has, I am very humble way I am, let's say, 34 has gone change over the last year. I also do not know what exactly is the prevailing law. 34, as regards 34.
On the last date of before his retirement, three judgments on arbitration. That even in-house that has been, I think, rightly done.
It is rightly done.
Rightly.
But the
In-house arbitrator.
confusion amongst we lawyers were created regarding the stamping. On the stamping, if the arbitrators decide, it becomes a part of the award.
Yes. But in-house, I think rightly it has been. Okay. 16th we'll have.
My lord.
16th, but kindly refresh within maybe 10 minutes. We have noted down what you have said.